Hello, my name is Clare Gilroy-Scott and I'm a partner in the employment team at Goodman Derrick. In this podcast, we're going to look at some of the changes coming in from the 6th of April 2020. Now, I first wrote this session to be given in a seminar, so it has now been adapted. I've tried to strip it back really just to focus on the changes coming in relation to statements to main terms and conditions of employment. So these are the two things that are coming in from 6th of April. As I said, changes to written terms for all workers, and then we will have a quick look at changes to the holiday pay reference periods. So starting first of all with the written statement of terms, many of you will be aware that employers are required to provide certain terms in writing to employees, and these are sometimes known as Section 1 statements because they derive from Section 1 of the Employment Rights Act, and that section pretty much lists all the terms that need to be provided in writing if you want to refer to that. I do have a slide later on which lists the main terms. Now, a Section 1 statement isn't necessarily a contract in itself, and sometimes it will have to include details of non-contractual entitlements. Good drafting will ensure that anything that is non-contractual is clearly stated to be non-contractual. Basically, it's a statement of the main terms. It doesn't require express agreement, hence we generally call it a statement. But sometimes these minimum terms are already covered in a contract of employment, which will contain fuller, often enhanced terms. If there isn't a separate written contract, having a Section 1 statement is going to be pretty indicative of the terms that will apply. Where there is a separate written contract, then the contract itself will always take precedence. So what's going on the 6th of April? Well, basically, you just have to include a few more terms in writing. So let's look at what needs to be included. First of all, hours of work. So at present, employers do have to include details of the employee's normal hours of work. The change now is that you have to be a little bit clearer. So currently some employers set these out as just being a total number of hours per week, or otherwise say that hours will be worked during core office hours. You do need to now provide a little bit more detail, including setting out the actual days of the week that the employee is required to work. You're also going to need to state whether working hours are variable. And if they are going to be variable, you need to be very clear as to how any variation is determined. So for example, where there is a shift rota, be clear about this. If overtime is required, be clear about how this is determined and whether it's paid or unpaid. So moving away from hours of work to other new provisions that need to be included, you already have to include information about sickness and holiday leave and pay, but you now have to be specific about whether there is any other paid leave entitlement that applies. So here, the most obvious types would be whether there's any enhanced maternity, paternity, or other family leave pay applicable. But think about other less obvious paid leave entitlements, for example, paid compassionate leave and time off for studies, etc. You also need to include more detail about benefits provided, and this could include things like private medical insurance or childcare vouchers, for example. Now, remember that often these benefits are provided on a non-contractual basis, so you're going to need to think carefully about how this is worded in the statement of terms to ensure that you don't unintentionally make the benefit contractual. And now also remember, if you don't provide any benefits, that this must be explicitly stated in the statement. So there's much debate still about the extent of detail which needs to be provided. But the idea about expanding upon these statements of main terms is basically to ensure that the information available to the employee is as useful as possible. So we suggest covering all benefits which are generally offered, which would have some sort of economic value. There are also new requirements to detail terms of any probationary period, including conditions that apply during probation and the duration of the probation. Again, probably most employers already include this in their contractual documentation, but key conditions should include performance monitoring and notice period during the probation. And remember, if it doesn't apply, then just state that fact. Then there's a new requirement to include information about any training entitlement which is provided by the employer. In practice, employers often provide ad hoc training to their employees, but not necessarily a formal training program. If this is the case, then that needs to be stated. So an assessment is going to need to be made to decide whether there is a training entitlement. For some professions, such as accountants, solicitors, and surveyors, there is a formal requirement to set out a number of hours of CPD training each year. But for many other roles, there isn't, so the situation could be far from clear-cut. You do also need to state whether any training is mandatory as part of the role, and also whether any mandatory training must be paid for by the employee. And in most cases, the employer will pay for the training, but this may not always be the case, so do give it some thought. If no training is provided at all, this should be stated. However, we imagine most workplaces will provide some type of training, for example, relating to health and safety or data protection, for example. So those are the new terms that have to be included in your statements. There are also other changes in April, and perhaps the biggest change is that workers will also be entitled to receive a statement of their terms, and currently only employees are entitled to this. Broadly, the same rules will apply to workers as employees. The notable difference is a worker will not have a date of continuous service in their statement. However, some of the prescribed terms in a Section 1 statement wouldn't normally apply to a worker. So giving you an example, the legislation provides that the statement of terms must specify the person to whom the worker should appeal if the worker is dissatisfied with the disciplinary decision. But most employers would only apply their formal disciplinary process to an employee and not to a worker. And this is for two key reasons. Only employees have a legal right to bring an unfair dismissal claim. And secondly, by exerting such a level of control over an individual, it could in fact indicate that they are an employee rather than a worker. So employers are going to need to think carefully about how they can satisfy the requirements set down in Section 1, but not inadvertently expose themselves to an employment status challenge. So it's not going to be appropriate to use exactly the same document for both employees and workers. And remember, if something does not apply, then this must be explicitly stated. With your worker statements, be careful not to use terminology you would use for an employee. For example, use the word engage rather than the word employ, and don't refer to the employer. Think about calling it a company or naming the actual business, for example. And although it's not a requirement, we do suggest that the statement is clear that it applies to their engagement as a worker and that they are not an employee of the business. So what else is changing? The employer is no longer going to have up to 2 months to give the document to the employee, and instead it will need to be given to the employee either before the employment starts or at the very latest on the first day of employment. Before we all panic though, remember that this is actually just a statement of main terms, so it doesn't have to be a full contract of employment, and the terms do not have to be agreed in the same way. If you're not in a position to agree a full contract of employment before day one, it may be possible to provide the statement in another way, such as in an offer letter, and expanding upon that in a more detailed contract of employment. Also, currently, Section 1 statements don't have to be provided unless the employee has at least 1 month of service, but this requirement is going, so it doesn't matter how long the employee or worker is actually going to be with you. Now, also the updated version of Section 1 statement terms should be provided to any employee joining on or after 6th of April 2020. But if an existing employee requests a new written statement, then you do have 1 month to provide that to them. We suggest if you're changing the terms of any existing employee's contract, for example, if they've been promoted or you've agreed a different hours of work arrangement, this will be an opportunity for you to update contracts to include the new requirements. Now note that there are a few exceptions to the day one requirement, and there is some flexibility about whether some information can be included in another document, but this is as long as it is reasonably accessible. And this is only in respect of certain terms, so you are going to need to actually check. I've now reproduced on the following slides the information which has to be provided in one document. So there are 3 slides. This is the first slide, and this slide basically lists all terms that have to be included in what we generally think of as the principal statement. So then continuing into the second slide, again, all of these terms need to be contained in one principal statement. And following on to the third slide. So what terms can be put into a different but reasonably accessible document? And that would include something like a staff handbook or a collective agreement. So this slide lists the terms that you can include in a different document, provided it is reasonably accessible. So I'm not going to go through those, as you can do that in your own time. So I'm going to just sum up with some practical points for you. Firstly, ensure that you review and revise as appropriate your employment contract templates. And remember to check whether this will also require changes to your staff handbook, because often employers include some terms of employment in their staff handbooks. Also assess whether you're going to be taking on workers following the 6th of April. And if you are, ensure that you create a separate worker contract or main statement template if you do so. And hopefully you will be ready by the 6th of April. As you can see, there isn't too much to change, but it is going to require a little bit of thought. So before we finish, I'm just going to summarise another change which is coming from the 6th of April. And this relates to how you calculate holiday pay. So where currently, if you're calculating holiday pay that is owed to a worker whose hours vary, you're supposed to use an average by looking back over a 12-week reference period. But from the 6th of April 2020, this is going to be increased to a 52-week reference period, or otherwise the total number of weeks where the worker has less than 52 weeks of service. And basically this is to ensure that workers who don't have a regular working pattern throughout the year aren't disadvantaged by having to take their holiday, for example, at a quiet time of the year when their weekly pay might be lower. And that's the end of our session today. I'm sorry if it was a little bit brief, but as I said, it was meant to be part of a wider employment law update. I will be recording a separate session to cover IR35, but pressure is slightly off in that regard because we now have until April 2021 before those IR35 changes come in. There is quite a lot of prep to do to comply with the IR35 changes, so I will record and circulate that session well, shortly, I hope. And that's the end. Thank you.